ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
3, 2, 1, start. This set of 5 appeals arises out of the common judgment and order dated 28/11/2017 passed by the National Consumer Disputes Redressal Commission, New Delhi, in first appeal numbers 1664 of 2017, whereby the NCDRC has dismissed the said appeals filed by the present appellants challenging the judgment and order dated 10/7/2017 passed by the Maharashtra State Consumer Disputes Redressal Commission, Circuit Bench, Nagpur. Stop. The appellants herein are the owners of the land in question. Stop. They entered into a joint venture agreement with respondent number 2, Mahavir Infrastructure Private Limited, for the development of the land and for construction of flats as mentioned herein. Stop. It appears that the appellants also executed irrevocable power of attorney dated 6/7/2013 in favor of respondent number 2 with regard to the said land. Stop. The respondent number 2, on the basis of the said document, entered into the sale agreement with the respondents' complainants for the units in question. Stop. The respondents' complainants filed the complainants before the State Commission under Section 17 of the Consumer Protection Act 1986 against the present appellants and respondent number 2, seeking inter alia the declaration that the present appellants and the respondent number 2 were jointly and severally involved in the unfair trade practices and were guilty of deficiency in service, that they were jointly and severally liable to complete the activities and construction as per the terms and conditions agreed upon between the parties, and put the complainants in possession of the properties mentioned in Schedule D after completing the construction, as also to execute the registered sale deeds in respect thereof. Stop. The State Commission, after considering the pleadings of the parties, allowed the said complaints. Stop. The State Commission, holding opponent numbers 1, 2, 3 liable for the completion of the construction of dwelling units as per the agreement to provide the possession of the dwelling unit, agreed in agreement to sell with each complainant in the span of 6 months from the date of the receipt of copy of this order, and the complainants to pay the entire consideration of the dwelling unit as per the stages, and the final amount at the time of sale deed and possession as per the agreement. Stop. After completion of construction of dwelling units as per agreement to sell, and on receiving full consideration as per agreement, as above, shall execute sale deed of respective dwelling units as per agreement to respective complainant. Stop. The complainants shall bear expenses for execution and registration of sale deed OP number 1 in the compliance of the agreement signed by the OP number 1 with the complainants as per the conditions of the joint venture agreement. Stop. The OP number 1 to provide the compensation of rupees 1 lakh to each of complainant for physical and mental harassment in the span of 1 month from the date of receipt of copy of this order, and on failure to pay, interest at the rate of 9% per annum upon it till the final payment. Stop. This appeal arises from a very unfortunate dispute about the custody of a female child whose present age is 2 years and 7 months. Stop. The mother of the child unfortunately died an unnatural death on 27/12/2022. Stop. It is alleged that the death of the mother was by hanging. Stop. The fourth respondent is the father of the child. Stop. By the impugned judgment dated 23/6/2023, the Division Bench of the High Court of Madhya Pradesh at Indore allowed the writ petition stop. It issued a writ of habeas corpus directing the appellants to hand over custody of the child to the grandparents stop. On 7/7/2023, this court issued notice and granted a stay of the operation of the impugned judgment stop. On 5/12/2023, this court granted leave and continued the stay stop. However, this court observed that it would be open for the husband to apply for custody before the appropriate court stop. As of this date, the husband has not applied for custody by filing proceedings under the Guardians and Wards Act 1890 stop. The appellants made such an application under the Guardians and Wards Act, but it was withdrawn later stop. This is the statement made by the learned counsel for the appellants stop. Now the question is whether the High Court was justified in disturbing the custody of the child whose age was 1 year and 5 months at the time of passing the impugned judgment stop. The learned senior counsel appearing for the appellants argued that by the impugned judgment without making any inquiry, the High Court has ordered the child's custody to be disturbed based only on the legal rights of the child's father and grandparents stop. He submitted that in the facts of the case, the High Court ought not to have entertained a petition of habeas corpus stop. He submitted that even if the petition was to be entertained, it was the duty of the court to see what was in the best interests of the minor, and custody could not have been disturbed at such tender age without considering the question of the welfare of the minor child stop. Learned senior counsel appearing for the respondents extensively relied upon decisions of this court in the case of Tejaswini versus Shekhar. Learned senior counsel would urge that the case is identical on facts where the High Court had declined to entertain the petition for habeas corpus by expressing a view that statutory remedy should be adopted for seeking custody stop. However, this court interfered and granted the father custody of the minor child stop. He submitted that the father and his parents reside together and therefore are in a position to take the best possible care of the child stop. He submitted that the appellants have not allowed the father to see even the face of the child stop. After having perused various decisions of this court, the broad propositions of settled law on the point can be summarized stop. Writ of habeas corpus is a prerogative writ stop. It is an extraordinary remedy stop. It is a discretionary remedy stop.